Hello, and welcome to the Argyle HR Leadership Forum. My name is Nick with Argyle, and it's great to have everyone joining us today. A couple of notes before I turn things over to our esteemed speaker. First, a quick reminder to stop by our sponsors' virtual booths at any time during today's event and for the following week. Our partners are committed to providing you with valuable content and a great overall experience. At any time during today's event, you can visit their virtual booths from the main agenda page, which include complimentary materials, information, and meet and greet opportunities. To ask questions throughout the session, simply type into the Q&A chat and we will address your questions at the end of the session. Now, without further delay, I would like to introduce our speaker, Scott T. Lashway. Scott leads Manat's cybersecurity and privacy practice and leads the firm's Boston office. Thank you so much for doing this, Scott. Today, Scott will be using a keynote presentation titled Data Protection in the Workplace, Compliance Update 2023. Welcome, Scott. Over to you.
Thanks very much, Nick. And thank you, everyone, for joining us today, whether you're live or watching by video. I'm going to provide an update to a program that we did just about a year ago, focused on kind of the HR and the personnel side of data management within our organizations. Some of this will update material that we spoke about last year, and some of it will address some new topics that are at the forefront of conversations in the country and probably conversations within your organization. For example, artificial intelligence. The slide deck I'm going to use will be available after the program. I'm not going to cover all of the material in here, so please feel free to take a read through once the program's over and use it as you so desire. So we start with the threat itself. So on the security side, this threat is not relenting. It is consistently evolving, and we'll talk a little bit about what security means to data protection in the HR space as we go through today's materials. But it's always a good reminder on where does privacy and security meet one another? Well, certainly when you have a security incident or say a data breach, we're all reminded about daily hygiene for maintaining and securing the information of our personnel, our employees, and all the vendors with whom we do work from the HR space, and how critical that is to reduce overall risk to the populations we care about, including not only the organization, but its constituents and employees. Palo Alto is a leading technology and security vendor, and we look to a number of annual reports to kind of get a whole overall assessment of where the security risk sits in the Western countries and here in the US in particular. If you look at Palo Alto's incident response report from 2022, there's a couple noteworthy things, and these are consistent year over year. But there's obviously been a lot of attention on ransomware, and then there's continued to be attention on business email compromise. Business email compromise is when one of your employees gets phished or otherwise suffers a compromise to their work email, and that work email is used for some sort of propaganda to either steal information, send out spam or more phishing emails, or to steal financial assets that belong to the company. This has been going on for a long time, and it continues to be remarkably financially productive for threat actors. If you look at the second data element, we look at where are the intrusions occurring, and there's a lot of technical jargon that's in these reports. But if you look at phishing, which is the first one on the list of 3, and then brute force credential attacks, that's typically meant to describe when one of your employees' login credentials are overtaken through some sort of brute force attack through a bot, or they're phished through social media. You know, we can figure out who the controller is at your company. That accounts for 77% of the overall intrusions reported in the US, as reported by Palo Alto. So what that tells us, just 2 little data points, is that our employees still are at the front line of securing not only their data that the organization holds, but the assets that your company is in charge of protecting. We look at phishing just for an example. And a few years ago, we were looking at phishing emails like the one on the left side of the screen, where if you clicked on that PDF attachment, whether you're supposed to be receiving this email or not. It's written in a way that would certainly get an employee's attention. Geez, why am I receiving an email from the New York State Association of Alcoholism? That PDF attachment had malware in it, and that malware was launched, if you clicked on it, automatically behind the scenes without the employee knowing about it. So they would have closed the email, thought, boy, this is junk, it's not mine. They would have deleted as an employee would. And unless they were trained to do so, they probably wouldn't have taken further steps. And so the threat actor was off and running, trying to get access to the company systems. Today, our employees are dealing with all new kinds of forms of phishing. The one on the right, often referred to as smishing, it's an SMS text message where if you click on that link, it also launches the ability of the threat actor to start trying to gain control over your company's user credentials. It is constantly evolving, and they're constantly at the front lines. So just to continue to set the table here for what we're talking about, these are a list of things that organizations who are focused on privacy and security-centric cultures, and we'll talk a little bit more about this at the end of the program, are focused on and are doing on a regularly routine basis. So some of them jump off the page for HR executives and personnel and leaders in that space, right? So preparedness and testing, that includes preparedness and testing with your employee population, understanding what the risks are, what the obligations are, where do they come from, and what their roles are. Workforce education and training goes hand in hand with preparedness and testing. Written policies and procedures and data management. We ask all of our employees to have good hygiene with respect to not only handling data, but creating data, creating duplicate copies of data, where they're storing that data, where they're transmitting it. And now that we've all come back to the office a bit, but are also still often working from home, we're in this dangerous space of having an office at home and having an office in the office and constantly carrying our technology back and forth, and therefore our access and all of the data we can access, all of the property and assets of the organization we can access back and forth, right? Workforce is now probably more mobile than it's been in years. And this creates additional challenges and additional needs for having workforce education and training, written policies and procedures. There are other things on this list where you might think, geez, I'm an HR executive, and why would I ever be involved in risk and gap assessments? Well, we'll talk about this in just a second on the next slide, but it's become critically important for HR executives to be in the room having conversations about building privacy and security-centric cultures. Both of those risks, and they are separate, though they're often intertwined, as we were just talking about, are not the sole responsibility of technology departments. For years, we said, well, the IT department is responsible for maintaining our systems, and therefore the IT or the security department's responsible for maintaining the security of those systems. They might ultimately be responsible for some of that activity, but they need to rely on you as a leader in an organization to get the workforce behind owning their own responsibility with respect to all the things we talked about: data hygiene, data management, data transmission, data storage, and data creation. So this is a list of things you can take back to your organization, speak with your IT or security leadership and say, if we're doing these things, I want to be involved. I want to understand what role I can play in all of that. And how can I be a better partner to you? Now, there's a lot of attention that's been paid whether cloud environments are more secure or less secure. And there's a number of very significant and very substantial and very cool technologies that you all might use that are in the cloud. And these help you perform your basic employee management. There's a couple that obviously lead the industry globally. They're all cloud-based, meaning that the data is often stored on the vendor systems. What I often see in organizations is, well, HR does their own thing. HR has this technology and no one else is allowed access to it, or it's very confidential, and so it's kind of shut down. The thing I would encourage you to think about is some of those cloud programs bring with them risk that you need to understand if you're the owner of that technology or the user of that technology. And you need to partner with your IT and security group to understand what those risks are. So is it configured properly? How are we using it? How are we storing data? Are we getting rid of data properly? Are we just making the proper disclosures with respect to collecting and processing that data? Are we sharing data out of those cloud environments with any third parties, such that there's disclosure obligations. We'll talk a little bit about this today as well. But in short, your reliance on cloud environments brings with it responsibilities that you would have as an HR executive within your organization. And that responsibility can be discharged by having constant communication with your IT, information security, and other technology leadership. So first question, for data privacy, shouldn't this be the responsibility of IT? How are we as HR leaders able to assure compliance? So we're going to talk a bit about this right now. So it's a great question. But in short, it's not your job to assure compliance. It's your job to be a participant to ensure that the employee base is aware of the privacy obligations that the organization has. One of the most significant challenges with, say, the development and evolution of US privacy laws, as well as security obligations that we'll talk about, is it's putting your organization on the front lines of this compliance obligation. But what do we think about when it's the organization? Ultimately, those responsibilities fall on individuals within the organization, whether they be leaders or individual contributors. And we think about how can those people understand what it is that we as an organization have to do from a compliance perspective with, say, respect to the California privacy law. That's a very difficult thing, right? So that employee doesn't have privacy training, they don't have privacy know-how, and it's not their job every day. Their job is to do something else, make money for the organization through some other mechanism. So your job as an HR exec is not to assure compliance. Your job is to make sure that there is a mechanism for which the employee base can assure compliance holistically. HR at times has had a really loud voice in some organizations, and in other times has said, this really isn't us. But we act in this space through our employees. So that's really what I'm trying to drive home. And we'll be revisiting that theme over and over and over again. So there's been a lot of conversation about the evolution of privacy laws following Europe's lead, which passed its GDPR and that became effective in May of 2018. California is more or less led the way here. They've got it right, they've got it wrong. It's messy, it's not great, it's hard to understand. They had provisions that were initially exceptions, and then those exceptions sunset. One of those is the handling of employee data. We'll talk about that. But not to be left behind, we have all of these states who are currently either in effect or will be coming in effect soon, or will be coming in effect in the next couple of years. We know there's a number of other states that are actively considering all of these. Massachusetts, my home state, is one of them. I would say that in short order, we're probably going to have another 10 or 15 privacy laws come online. Just generally speaking, these privacy laws are all very nuanced and very complicated, not to read and understand, but to apply to your organization. And this gets back to the question, how are you supposed to assure compliance? You are not supposed to assure compliance, but your employee population needs to understand what their obligations are with respect to data. And how do you do that? Well, we have to first start understanding how do any of these laws actually apply to us, whether they impact our business, and whether that impact or the risk around that impact can be mitigated. That's the job of legal, that's the job of HR, that's the job of IT, IS, compliance, however your organization is established. But it starts with probably some really solid legal advice. And let's talk a little bit about some of the legal advice that is required. So I'm not going to read this slide to you. This slide's been updated since we spoke about some of this last year, but doing a deep dive in California is a good exercise to understand where these privacy laws start regulating the handling of, say, employee data. So for example, California requires that you have a privacy statement that's provided to employees of vendors, customers, and partners. You need to operationalize the California law's basic rights to know, rights to collect, to delete, to opt out of the sale or sharing of personal information, the right to restrict use of sensitive personal information, and the right not to be retaliated against. As an HR executive, some of those certainly will ring true if you've ever dealt with an employee who's being terminated for cause and said, well, it's not my fault, you did something to me. This is a mechanism that can now start to be used by employees or outgoing employees to put pressure on the organization to comply with basic privacy rights. California applies to California residents. And so you think about, geez, if I have operations in California, or if I have personnel that are living in California, then we need to start paying attention to the California law. And that would ring true for all the other laws that I had on the screen just a second ago in basic terms. So the bottom line is more companies will say that they sell data in the coming years, and there's more operational complexities. I'll give you an example. If you're an organization that benchmarks employee data for, say, compensation purposes, you will want to think about how you can use that California data for benchmarking purposes. If you're sharing it with a third-party benchmarking organization, which a lot of organizations do, you'll want to understand whether or not you can share it. Have you disclosed this use under California or other applicable privacy laws? And whether there are ways to aggregate and anonymize that data that would potentially avail yourself of not being regulated by the applicable privacy law. So, second question of the day, this is a question we get all the time, and I have a terrible answer for you. What is the best way for us to track the latest legislation on workforce rules, privacy, and data security? So the problem is there's no easy way. There are trackers out there, there are vendors out there who will provide you kind of synopses of what these laws say. The real challenge is not just what they say. First of all, you got to get that right. That seems complicated for some. But most importantly, how does it actually apply to your organization and your use of the data? So that example I just gave you, there are probably ways you can mitigate risk by sharing benchmarking data, ways like de-identifying or anonymizing, aggregating the data in ways to ensure that you're no longer dealing with regulated data. Doing that from an operational perspective sometimes is more challenging than one would want or one would expect. And there's no easy outs in the privacy laws that say, well, if you do this, then you can go and use it. We'll talk a little bit about that in AI for a minute. So sorry, I don't have a better answer for you there, but my answer, which of course is biased as a lawyer, is you should have a really good privacy lawyer around. Let me talk a little bit about employee data protection rights. So here are some other kind of practical takeaways, and it goes to your question of how do I keep track of all this? So Colorado, Connecticut, Virginia, and Utah. So Colorado exempts from its coverage data maintained for employment records purposes. So obviously that's a very big win for anyone operating or having personnel in Colorado. Virginia also has an exemption similar to what Connecticut and Utah have. Interestingly enough, unlike California, each exemption appears complete and does not include a sunset. So originally California exempted employee data, and then that sunset. The legislature didn't act, and so it now regulates employee data. State law tends to exclude individuals acting in a commercial context, and the company may still be selling personal data even if it's not required to provide do not sell rights. So one thing to be thinking about in my benchmarking analysis is, and this is where I was getting at in terms of having a really good privacy lawyer around, is even if there are no do not sell rights offered by a particular state, not all states have California's do not sell obligations, there still may be operational or even legal obligations with respect to selling personal data. And selling data, just to put a pin on this, at least under California, is in the broadest sense. So if you share regulated data with a third party, it is safer to assume that that might be a sale under California than not, even if you're not trading it for money. If you're trading it for anything of value, including getting data back, like a kind of a quid pro quo or a give to get model, then you may be selling data under one of these laws. Another area that employers need to pay particular attention to, if you haven't already, is biometric data regulation. So Illinois has by far the leading statute in this space. It's called BIPA. There are, on any given day, typically 200 plus active lawsuits under BIPA. They're often against employers. They're often related to the use of technology in certain industries with respect to clocking in and out. So think of the warehouse model of using a thumbprint to clock in and out instead of the old time card. It also often will include things like voice print. And so as we think of things like Apple's, Siri technology for authentication and other similar technology for authentication or used by employees, whether it's authentication for access controls, clocking in and out, monitoring an employee within a building or within their workspace. These are all things that can come within the confines of certainly Illinois and possibly Texas and Washington. Um, Generally speaking, the way you want to get through this is, again, have a good privacy lawyer, but you want to provide notice and receive actual consent to both collect the biometric data and to use it. Illinois gives you a certain period of time for your ability to hold that data. There's a dispute, and this is where the real risk starts materializing in significant ways. There's a dispute under Illinois law that the courts have been speaking to about whether each time you collect that biometric data is a potential new violation if you're not complying with the obligations there. And there's a statutory fine available in Illinois that can become staggering. So if you have 10 people working in a warehouse that thumbprint in and out every day, and each of those is a violation, every day, you can immediately start thinking about how the numbers alleged by the plaintiff's lawyers is staggering. So if you're not dealing with biometric data, it's still something you want to be paying attention to. And in particular, more and more of our technology and our controls, including our access controls around, say, accessing our laptops and our computer, I think are going to continue to be turning to things like biometric data. We know passwords and usernames aren't particularly good security mechanisms. We know that multi-factor authentication, so a secondary level of authentication, is critical. And so we're going to, I think, continue to see the development and implementation of biometric collection technologies for simple purposes like logging into technology within the organization. So we get a lot of questions about, are we ever going to have a federal privacy law? And I would say we're probably closer to having one than we've ever been before. We probably would have one if Washington was a bit more efficient and functional these days. Interestingly enough, there seems to often be some appetite from both the blue side and the red side. And if you go back to my initial list of states that have laws or have enacted privacy laws, you see some both red, purple, and blue states. We certainly think there's going to be some continued evolution of privacy rights in the red states as well, even though it's often been kind of a blue state type thing. And so we're close. I think there continues to be some major hangups in addition to Washington's inability to function on basic levels. One of them is whether or not there'll be a private right of action. And this would be a private right of action to sue a violator. So this is your your employee who says you violated my federal privacy rights under this law, and I'm now going to sue you. The current bill called the American Data Privacy and Protection Act that was proposed last year, it was reported out of committee in December of 2022. It was not passed, and it has not been reintroduced into the current 118th Congress. It's closer in form to the CCPA, the California law, than other US comprehensive privacy laws. So if you compare it to California versus Virginia, Virginia is a little bit closer to GDPR and the concepts that it deploys. But it does create these rights of access, correction, deletion, and portability. This could potentially create pretty significant headaches that you'll have to lawyer your way through with respect to, say, departing employees. So an employee who's leaving, say, under unfortunate circumstances and says, well, I want all my personal information deleted. That includes, but it's not limited to, all the emails I've sent and received. Of course, those belong to the company. They're not personal data, even if their personal data is included in those emails. And so we would just need to sort through some kind of basic logistical and logical applications of the law if we ever to have one. Another big thing, a big hang up, is whether or not it would preempt most state privacy laws. Obviously, some states like California want to kind of control their own destiny with respect to regulation of privacy. And that's not, I think, perfectly settled at this point. And certainly things like whether it would preempt, say, the Illinois biometric law, whether it would cover employee data per se, whether it would preempt student privacy laws under federal law, are all things that still need to be ironed out and clarified and more clearly written. But we are closer. I will just tell you, these are my views, not the views of any of our clients, but I'm not sure if federal privacy law makes things simpler for organizations right now. There is this idea about how far are we going to go with the states before we have a real mess on our hands, and we certainly have one that's emerging. But we do have kind of basic principles around privacy laws in the United States right now with respect to the handling of, say, employee data that we're able to identify and follow. Let me just give you an example of the shifting regulatory landscape. Now, some of you this may not apply to at all, but it's an important little case study. I'm going to try to do this really fast. The FTC is looking to amend their breach notification rule. This is covering healthcare data that's not regulated by HIPAA. So HIPAA is specifically defined in regulated data. It's called PHI. We often use PHI to refer to healthcare data when it's not PHI under HIPAA. The FTC regulates some of that use of other healthcare data, in particular, say, for example, wearables. So if you have a heart rate monitor and you're collecting data and it's shared with the company that produced the heart rate monitor, or say your watch that tracks particular health information. This is where the FTC comes in. The FTC has come out and said, well, not only are we going to enforce the health breach notification rules that we have on the books, but we're also going to look to amend our regulations and ensure if you're collecting this data, we're going to regulate it. We're going to hold you accountable. And they've brought not only new regulations to the table that would arguably expand the scope pretty significantly of this rule in terms of its coverage and application to healthcare data, including potentially, say, to employee data that you might be collecting on the side because you're interested about, say, your employees' wellness and well-being outside of HIPAA. But they're also bringing enforcement actions. Now, right now, they're focused on tech startup companies or companies that are using and collecting this data. But we all should be very mindful of whether we're collecting healthcare data from our employee base that might be covered not under HIPAA, but under the FTC's health breach notification rule, which really regulates its use and disclosure. So we gave you some information in here that I'm not going to run through. All right, so let me just talk about AI. If you could offer one piece of advice to HR leaders about governance trends, what would it be? Where's the biggest focus? Let me talk about AI, because it's a topic where we get a call about once a day from clients saying, my data strategist, my HR group, my whomever wants to use AI, and they think it's a great idea, and the rest of us think it's a terrible idea. So where are the winds blowing? So obviously AI is changing how we all work. It's changing the discussion around the use of technology in our environments. The key to AI is understanding who's providing you the technology. Do you know who they actually are? Who's behind the technology? Where did it come from? And how is it going to get into my environment? As HR leaders, I encourage you to ask these difficult questions to anyone wanting to use AI on your employee base data. It is very critical to understand, can you use employee data in AI? Do you have those rights? The privacy laws prevent you from doing this. There are AI regulations that exist at the state level that have been out there for a while. These are all things that you need to be asking about. And the place to begin is creating some basic structure in your organization around the deployment of AI and whether or not employee data can be used. The starting answer should be it cannot be used unless it's proven that we can use it. I'm not against AI. I think it's brilliant. But we need to understand what we're going to be doing with it and how we're going to be doing it and what data we can and can't use in those technologies. Obviously, that applies to any new technology coming into the organization, but we all know that there's a lot of pressure using AI because a lot of people think it's going to solve a lot of problems that we haven't been able to solve efficiently before. So that's one piece of advice I would provide to HR leaders about governance trends. Another piece of governance trends, and I'm probably going to end here given the time, is there is a lot of risk that's being borne now by our leaders in our organizations. So Delaware, we look to Delaware throughout the United States for leadership on corporate governance, how our organizations are run and led, and what our obligations are as leaders, as officers and directors. Delaware has said now that cyber risk is a part of corporate governance structure. So there might be fiduciary obligations by your leadership, by your officers and directors to deal with cyber risk. I would argue that relates probably to privacy risk now too, within the organization. And those obligations are things like duty of loyalty, duty of care, which involves caring for the assets of the organization. Delaware then came out in a different context. And if you haven't read this decision and you're an HR leader, I would encourage you to read it. You can find it on Google. It's the McDonald's case. It's not about cyber. It's not about privacy, but it is talking about officers having obligations of oversight. So obviously officers are the leadership of an organization, and a legal officer having responsibility for legal oversight and for making a good faith effort to establish reasonable information systems to cover that area is something that's spoken about in here. And it brings with it a whole new attention on potentially personal responsibility for our actions within an organization as leaders. And this is an interesting read, and it's really informative, and it kind of gives you a sense of where we're headed. Of course, I know I'm running out of time, but privacy and security centric culture is something that is critical. We gave you some slides in here and some ideas on how to develop that. I'm always available to answer questions offline. But this is a place where, going back to the initial question, how are HR leaders able to assure compliance? Again, you're not, but helping to create a privacy and a security centric culture is something that you can play a huge role in. So I am out of time. Thank you for listening to me drone on for 30 minutes. And with that, Nick, I'll throw it back to you. Thanks for having me today.
Great. Thank you again, Scott, for such an incredible keynote. And I want to thank everyone else for joining us today. This session, along with all of today's content, will be available on demand following the event. This officially concludes the Argyle HR Leadership Forum Trends, Tech, Talent. And a very special thanks to today's sponsors, GP and Checker. This event would not be possible without their support. Thank you again, GP and Checker. Thank you again for joining us today and engaging in our content. And have a great rest of your day.